speaking with me, Tarun Nangia. Delhi High Court has a list of many firsts to its credit, but this time it has gone ahead and created the first intellectual property division in the country for any of high courts. Of course, it's known as a very progressive high court with the kind of judges that we've seen elevated in this high court. And as usual, this is another first for this high court. And why is it important? Important in a way, why does it show the way to other high courts? We will discuss today. I have a very eminent panel with me. May I welcome Justice Rajiv Sahai and Law on the show today. I have also Senior Advocate Saurabh Kirpal joining me. I have Advocate Saket Sikri joining me. Welcome all of you, and looking forward to some very interesting interventions on this very interesting topic on setting of the IP division at Delhi High Court. May I request at the outset, Justice and Law, for you to open and in about next 2 minutes set the ground for what the Delhi High Court has done and explain us the importance and the intention behind such a move.
Thank you, Mr. Nangia. See, the Delhi High Court has always been aiming of ways and means to expeditiously settle the cases and somehow get out of that infamous thing that the litigation takes too long, and in which direction it has succeeded to quite an extent, because at least in the IPR cases, we have seen a preference for approaching Delhi High Court vis-a-vis other jurisdictions. I have known of cases where people have shifted their registered offices to Delhi to be able to avail of the Delhi jurisdiction because of that judgment which had come that you can sue at the place of your registered office. So that was the primary thought, and this thought had been going on for about 3 years. And why specialist courts for IPR cases? Because IPR cases, over a period of time, it was felt, required a specialized knowledge and a knack to handle. They were out of the stream of the ordinary civil suits which were happening. And this experiment had succeeded earlier, about 10 years back. The special benches for the arbitration cases were constituted. And it was found that the disposal of arbitration cases went up. Instead of all 6 or 7 benches dealing with them, to give it to this. The other factor, of course, was that with the impetus was provided this time with the Tribunal Reforms Ordinance, and which ultimately became the Tribunal Reforms Act. Several tribunals were abolished, and one of the tribunals to be abolished was IPAB. Now, IPAB was a specialist court which was set up. It was envisaged in 1999 when the Trademark Act had come, but ultimately got functional in 2003, and which, besides the judicial member, also had technical members. So that was at par with the specialist IPR courts in several other jurisdictions across the world. There were just 6 or 7 countries which had such courts, and it was hailed to quite an extent when it had come up. But somehow that experiment did not succeed. And when those cases which were pending before the IPAB came before the High Court, a large chunk of them came to the Delhi High Court, because, as I said, the IPR litigation is maximum in Delhi High Court, or we should say in Delhi. So at that time, a need was felt to make rules for them. The Delhi High Court had been in the process of making rules for decision of patent suits, which again, the procedure of the ordinary suit was found to be lacking to deal with patent issues. So that process was going on, and then simultaneously this IPAB got abolished. So the 2 streams were merged and the IP division was constituted.
Thanks so much for that opening comment and explain it in detail about how these things happen. I'll go to Senior Advocate Saurabh Kirpal for his opening comment on this decision and the operationalization of the intellectual property division at the Delhi High Court.
Thanks for having me again, Mr. Nangia. And really, after a person as with a luminary like Justice Enlaw says something, there is little for me to add. But I'll just point out by drawing one parallel, as Justice Enlaw rightly said, is that we've had an experience in the past with the arbitration roster, with a degree of specialization, which enables a faster adjudication of a dispute. Now, while it is all well and good to say that we must have generalist judges and specialists, it is important also, I believe, for a judge to be fully immersed in one kind of jurisprudence. So there is a consistency of views. So it is very important, rather than getting absolutely disparate judgments, one saying one thing, another judge saying another absolutely different thing, that there is a consistency. So setting up of a separate division ensures that there is consistency. There is also expedition, as Justice Endlaw rightly said, because once the judge is immersed in that particular jurisprudence, they know all the nuances, they understand all the law. They do not have to spend time in acquainting themselves. And we frequently forget that judges are also humans. And while they may be repositories of great knowledge, there is always some area of the law which they will not be as familiar with as some of the other lawyers. So this is also an occasion for some of the lawyers who are experts in the IP area to engage with the judges so as to enhance the quality of justice and decision making that happens. So these, I think, are the broad reasons as to why the IP division has been set up. And as to its operationalization and how it's working, I think there's no one better than I can see Mr. Nair there. He is the leading member of our bar who argues probably the most matters there. So I think that's a question that you can ask him.
Okay, thanks so much. Welcome, Mr. Nair. So we have Senior Advocate Rajiv Nair joining us. And as I was telling just before you joined, that Delhi High Court has become the first High Court in the country to have an intellectual property division. This is among the many other firsts that the Delhi High Court has had. And your opening comments on this, in a sense, decision, and also what do you feel and why is it important that we got it?
Thank you, Tarun, for having me on the show. And I'm in esteemed company of distinguished persons led by Justice Endlaw, for whom I've always had a very special fondness and regard and respect. Now, I think before I answer this question, I think the setting up of intellectual property courts, according to me, is only a precursor to the substitution of tribunals by courts in the long run. I think the government has realized by the amendment of the Trademarks Act that this experimentation of tribunals has failing to some extent. And I have always maintained that it's better to have more judges than tribunals because there's consistency of judgments and there's also intellectual advancement, because according to me, tribunals have completely failed, and you can take the case of the NCLT and the NCLATs and all those. And I think it's only a matter of time before they are also abolished and the courts will be dealing with that. But that's the first. So therefore, in my submission, the fact that dedicated judges have been assigned to the intellectual property cases is in consonance with the overseas, particularly in England, where you have specialist judges looking after specialist matters. If you are a maritime, there's a specialist maritime judge, specialist intellectual property judge. So therefore, this is actually bringing into India specialized judges into specialized jurisdictions. Now, for instance, of the two who are currently in Delhi High Court, Justice Pratibha Singh has all her life practiced in the intellectual property side, and she's familiar with all the nuances of trademark and copyright law. So therefore, it's always an advantage to place people like her into the intellectual property division. And I must say although we are giving credit to the present Chief Justice, this credit must actually go to Justice Endlaw, because he's the one, while he was in office, had advanced this and suggested this. He had said, please have specialized persons sitting on the intellectual property side, and which is now fructified. So it's a telling thing about what had happened earlier and his recommendation, which has now come into vogue. I think by and large, this specialization, specialized judges sitting is nothing new because we also earlier have judges sitting in the arbitration side. So you have 3 or 4 dedicated judges. So Delhi High Court is first in many fields because you have dedicated arbitration judges, you have dedicated copyright judges, you have dedicated suit judges. So therefore it's an amalgamation of the great. And as I've always maintained, for the sake of being criticized by others, there is nothing better than the Delhi High Court in all respects.
Thank you for that telling comment on the IP division that has been set up at the Delhi High Court. I go to Advocate Saket Sikri, who practices at the Delhi High Court and the Supreme Court of India, for his opening comment on this occasion.
Well, thank you, Tarun, for having me over with such an illustrious panel of Justice Anlo and Mr. Nair and obviously Mr. Kripal. There is not much I can add to it. But like I said, it's a step in the right direction. Having a specialized IP division will actually send out a good message, not just within the country, not just in the industry, but also to the international fora. So there is a clear direction that there is an IP division which will take care of the IP litigation specifically. And, Delhi High Court, of course, we have Justice Anlo and Mr. Nair here, but Delhi High Court has been a pioneer in IP litigation from the very beginning. Of course, for the last 20 years, it has done some exceptional work and laid down the law on IP. But even if you go back to the 60s and the 70s, some judgments that were there, even on issues like passing off, trade dress, trademark, we have some landmark judgments. So, from the very beginning, we had Delhi High Court as a very important court for IP, which is why we could have lawyers who today heading the IP division, that is Justice Pratibha Singh. So that is one part of this IP division, which I found that it's very important for quick, expeditious disposal. Now, from trademark and trade dress disputes, today what is very important are the patent disputes. And in patents, what is important is quick disposal. It has to be disposed of because patent has a certain life. Now, if a suit continues for that very time, and the person doesn't enjoy the protection or doesn't enjoy a judgment from a court, then I would say it would not even solve the purpose of having such kind of a dispute at all. So therefore, this kind of a division, which will expedite the disposal of all these IP litigation, etc., will go a long way. And like both Justice Anlo and Mr. Nair said, Delhi High Court has had many firsts. We have seen the roster benches for arbitration, specific roster benches for arbitration. Now, those have been a great success. I think Delhi High Court has had, even in the field of arbitration, maximum disposal of all the objections. Similarly, in the IP division, I believe it'll be a great. I would actually look forward to seeing how we will go ahead and how these disposals will be taken care of.
Okay, thanks for that comment. Go to Justice Anlo. As far as you see that in Delhi, because all kinds of corporates litigate here, a lot of head offices are here and a lot of litigation jurisdiction in the end comes to Delhi. So the caseload of IP cases we can see is a lot in Delhi. Do you see further scope of expansion as more judges are added in the Delhi High Court? Do you think the IP division will only become bigger in the coming days? I want your comments on the same.
Certainly, Mr. Nangia. See, the intellectual property also has expanded from trademark, copyright and patent. Of course, design is some time old. Today we have the Plant Varieties Act. We have the semiconductor integrated circuits designs. Then a part of the information technology also falls in the intellectual property regime. The disputes relating to data, confidentiality, trade secrets, and under the rules which have been framed, all these have come within the ambit. So with the expanding scope of the intellectual property, and naturally the disputes are more with respect to intellectual property, and if the aim ultimately is to have expeditious disposal, then of course more judges are required. And ideally, there should be a division of 4 judges as per the prevalent numbers also. Because not only does it have the original disputes, it also has the writ petitions arising from various fora. It has the appeals arising from the subordinate courts. It has the revision petitions arising from the subordinate courts, then appeals from the earlier IPAB orders. So they are all under the umbrella of the IP division now. So yes, if we see as per the international standards, that how many cases should be there before a judge. Definitely, we need at least double the strength of what we presently have.
Okay, thank you for that input, sir. I'll go to Senior Advocate Saurabh Kirpal. With every, say, generation or every decade, the nature of the courts change. There are new ideas that come into play. There was a discussion that should there be a separate court for arbitral appeals because they need to be enforced faster. IP division is also a product of such a thought. Do you think, in a sense, the judiciary is evolving? You are seeing that specialization is needed. When you see these 30, 40 kind of IP matters, you can adjudicate better because then you're not dealing with two diverse matters. You're focused on the kind of matters. Do you feel that that age has come because there is so much of diversity that you need some specialization?
Yes, that's true, Mr. Nangia. But I'll say one thing: the judiciary has changed, but has changed in a cyclical manner. So what do I mean by that? And I here will refer to a bit of what Mr. Nair alluded to earlier, that when the independence happened and the courts were set up, there were only the civil courts in India, and they managed to do everything themselves. There was no problem. The dispensation of justice was moving. It became slower and slower and slower because our population expanded and the courts did not keep pace. The growth of courts did not keep pace. Because of that, we started looking for someone to blame, and we had a tribunalization of justice. We thought, wrongly as it now seems, that we could expedite justice by having tribunals and getting specialists there. Now, that is an experiment that has completely failed. Rather than moving and expediting anything, that has just become another clog. And that is why I believe the courts are again changing and going back to what's the original sense, which is a single court, uniform, which will have therefore the consistency of decision making. But even though we are going back to the olden times of having a single court, I don't think it can be business as usual for the courts as well. We need a greater degree of specialization. To have a judge who has practiced all their life on the civil side to be made to sit and decide criminal appeals and bails does injustice both to the judge as well as to the person whose appeals are being heard. Because these are matters of great moment for the litigants as well. And while we focus on judges and lawyers, ultimately this is nothing but a delivery mechanism of justice for the common person, right? So we have to make sure that today the system that is devised is one that makes the ease of doing business more. It ensures an access to justice, which can only happen when judges deal with areas in which they have a certain domain knowledge. So why just IPAB or indeed arbitration? This should be now the case the way it is in England with criminal appeals and criminal matters and family law. I think family law is something that is often given short shrift in our country, and given the increasing rate of divorces, that's another thing. So it's important for the judiciary to evolve and to have a greater degree of specialization. So
thanks so much for that observation, Senior Advocate Saurabh Kirpal. I'll go to Senior Advocate Rajiv Nair. Sir, I want to ask you this from what Senior Advocate Saurabh Kirpal shared with us. For example, take an example. There's a very complex construction dispute, and arbitration is being challenged in the Delhi High Court. Now, if the judge, in a sense, does not have that background, then of course it makes the job of a lawyer also much tougher because you need to explain those facts, and that is why specialization. Do you think we have already moved that path, and we will be able to see such things in many other areas, not only IP, but we will move forward that path?
Well, IP, criminal, civil, they're all very specialized jurisdictions. I won't know whether a subset of a construction contract, etc., will be a subject matter of a separate judge being sitting for that. So I think it is assumed that a judge who's hearing arbitration, who's competent to deal with arbitration matters or competent to deal with civil matters, would be able to look at construction contracts or anything disputes relating to that. But having said that, I agree with Saurabh in the sense that there's been a sea change. The sea change is not only amongst courts, the sea change is in the nature of the litigation. So whereas 40, 50 years ago, our Justice Andlaw's father, who was one of the most respected civil lawyer, would be dealing only with suits for possession, injunction suits, specific performance, etc., because that was the nature of the litigation. But since 1991, 1992, because I always thank Mr. Manmohan Singh for having changed the fortune of lawyers, the nature of litigation has completely changed. It's become very commercial in nature, commercial disputes, arbitration disputes. If you look at disputes under the 1940 Act, Justice Andlaw will tell you how many people actually understood the 1940 Act. But today, if tell somebody, everybody is conversant with the 1996 Act. So the complexion of litigation has changed. So if the complexion of litigation has changed, and we have to keep in tune with the foreign lawyers, because lots of arbitration jurisdictions, lots of arbitration contracts have foreign seated arbitrations, they have Singapore seated arbitrations. So you have to have people who are tuned with that specialization, because you are dealing with foreign enforcement of foreign awards, you are dealing with interim orders of foreign seated tribunals, you are dealing with orders of retired Supreme Court judges. So it's a complete sea change. And if there's a sea change in the litigation, you have to keep pace by having specialization amongst judges. There's no other way. You can't ask somebody to sit in income tax if he has no previous experience about it. Because you have now abolished you have abolished the tax tribunal. So it is the age of specialization. The sooner everybody recognizes, the better it is.
Thanks for that input. I'll go to Advocate Saket Sikri for his input now. In a sense, when we see the IP division at Delhi High Court, I think the court has taken into cognizance that then when these judges were lawyers, they would have dealt with IP matters. Do you think that was taken into consideration?
Well, I believe as it started, I believe Justice Andlaw was one of the pioneers in coming up with this whole concept of IPD. It is a specialized field. So obviously today the two judges, and interestingly, both the judges who are today on the IPD benches are both women judges. One of them being Justice Pratibha Singh, we all know. She was an eminent IP lawyer. In fact, subject to correction by my seniors here, she will be the first IP lawyer to be designated as a senior counsel. And then, of course, she's proved to be a great judge. And so she is one of them on the division, on the bench. And the other one being Justice Jyoti Singh, another eminent senior advocate, and now working towards this. So this is, of course, one aspect. The other is what Mr. Nair said, that we have to be specialized. Now, just coming quickly, two comments on the rules, how the ingenious rules provide for 2 extra legal researchers over and above the legal researcher that the High Court would give you. So, and those legal researchers which will be given to the judges of the IPD would have to have some specialization in IP. That will obviously ensure quick, speedy disposal. Now, if there is an IP expert who is assigned to IPD and will be helping the judge, and not one but 2, over and above the 2 researchers that are provided for, will surely help in expeditious disposal and bring in the expertise that we need. So, of course, today we have Justice Pratibha Singh, who's an expert in IP, but tomorrow the benches may change. So you may have a judge who may not have practiced so much on the IP side or civil side, but with these 2 experts who are experts in IP, there will be a chance of getting that expertise and delivering justice. That's one. Another very interesting part of the rule is that unlike a civil court where only advocates enrolled with the Bar Council can practice, there is a specific rule empowering the patent and trademark attorneys to have an audience before this court. That also shows and speaks of the expertise that we are looking at. Another very interesting part of the rule that I saw was, which is, I don't know, but I haven't seen any other rule, that there is also provision for disabilities. So if there is a person with any sort of a disability wants an audience, etc., he can also make a prior request and arrangements will be made on. So all this shows how what ingenious step this is. and how futuristic this would be, and how it will lay the foundation to many more things to come. Like we can today, of course, have arbitration. There is a roster. There could be some more specialization in it. We can have more benches out of it. That's one. And second, of course, as Justice Andlaw pointed out, this is an umbrella which will include all sorts of IP disputes. So not just the civil suits that come for infringement of trademark or patent. There are also appeals that may come from trial courts to the higher courts. Now, under the previous regime, that is just pre-IPD, I would say, this would not go to a civil judge who's hearing an IP matter. This issue will go to a appellate judge who's hearing appeals from all trial courts. So that vice is also taken care of by going to the same bench or the same division which is specialized in IP. Similarly, there were writ petitions that were filed in the earlier. There are writ petitions filed pertaining to IP issues against registrars, etc. Even those writ petitions are coming here. And of course, as Justice Andlaw and Mr. Nair specifically said, that all the jurisdiction of IPAB has also come here. So all in all, it's a very ingenious and great initiative. And I agree with Mr. Nair. I believe Delhi High Court is the best High Court and will continue to set many such firsts for the future. Thank you.
Thank you. Thank you so much for the comment. We're almost out of time, so I will have to request Justice Andlaw for his final comment before we end the show.
Yeah, I would. What I have read in the newspapers and on the High Court website, another very good fallout of creation of this division is that a spate of directions have been issued to the trademark office, to the patent office. Now, which also came to the fore the issue that what is plaguing those registries, because the one judge was dealing with IP cases, and from all the cases before a IP division, it was realized there was something amiss which was not happening. For instance, in the patent office, the complaint was that the login during the hearing had to be granted to the lawyer. So there were a lot of petitions coming before the court that we were waiting and we couldn't log in because we were not given access during the hearing. So a lot of directions have been issued. So that is another positive fallout, that there will be automatic supervision of the administrative machinery concerned with the IPR.
Thank you. Thank you so much for that comment. But I would indeed be thankful to each of my panelists today for making it on this show on such an important topic. Of course, this is a form of encouragement to the decisions that the honorable judges take at the Delhi High Court. Of course, this is a successive form of the system, as we all got to know today from Saket Sikri and Senior Advocate Nair, that it was indeed Justice Andlaw who had, in a sense, played a part in the initiation, which I frankly did not know about. But we all got to know about that. And we would continue to take up such issues whenever Delhi High Court comes up with these kind of decisions. I would like to thank Justice Andlaw's Senior Advocate Rajiv Nair, Senior Advocate Saurabh Kirpal, Advocate Saket Sekri for making time. And thank you viewers for joining in. Thank you so very much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.